All right, this is 242248FY, the People versus Robin Edison.
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Ms. Edison, who appears via Wayne County Jail.
All right, Ms. Edison, can you tell me your name?
Robin Lynette Edison.
All right, so this is the time and date set for the probable cause. Counsel, do you have all of the discovery on this matter?
I do, Your Honor.
All right, we need to set an exam date for Miss Edison.
And, Your Honor, before we do that, may we address bond?
Here's the thing. You can make your record. Go ahead.
Oh, yeah, I know I was in court a couple of weeks ago regarding Miss Edison, and unfortunately she did not make that date. It's my understanding that when I spoke with Miss Edison, she did not have transportation to make that date. Also, Miss Edison informs me that she has not had a tether on or an order for a tether since September.
When she cut it off?
I didn't cut it off. I did not cut it off.
I gave her a personal bond, Mr. Riggins. I gave her a chance. She was in treatment court. She went to treatment. I gave her an option and she absconded from treatment. And then she told the jail last time she was here that she had just used the day before. She was supposed to come in for a violation of probation or bond on her other case. And she came in and was supposed to be waiting. And instead she fled the court when she found out the recommendation was 93 days in jail. So here's what I'll say. And then, Miss Edison, I'll mute you. Here's what I'll say. How about this? All of this time is going to count against that probation violation when she's doing 93 days on anyway, if she's found guilty of absconding from treatment. So I'm not removing bond. I'm keeping Miss Edison alive for a few months and I'm not changing bond, period. She's a flight risk. She has a serious drug addiction problem and she's gonna either kill herself or not show up. So Mr. Riggins, you've made your record. She's been muted. That's my ruling. So let's find a date.
Your Honor, there's one last thing. It's my understanding that her father recently passed the 23rd of December. Her mother has dementia. At a very minimum, if you're not inclined to reduce her bond, actually she should be at least allowed to take care of her father's proceedings.
She won't show up. I'm not letting her out. I'm just not. I think I'm pretty reasonable. Miss Edison will abscond. Miss Edison will use, and she'll show up when she wants to show up. I don't have any documentation at this court that there's been a death in the family. And Mr. Riggins, you hear it all the time, and so do I. Someone died in a family, or they start a new job tomorrow. I've heard it. So.
I understand.
All right, bond denied. Her bond will stay as it is. And then let's set a date, Mr. Riggins. I've got the 7th or the 6th or the 13th. Both are looking rough, but we'll make it work since she's in custody.
The 6th and the 7th, I have I am in a very long preliminary examination that is scheduled for 3 days. I can make the 20th, the 13th work. Unfortunately, that will probably be my first day available.
All right. Well, the 13th is still. Well, that'll take us just over 21 days. Yeah, that'll take us to about 25 days. I'm finding good cause. We'll do the exam.
I can do the 9th as well if you're available.
The problem is I have a Wayne County prosecutor here for 3 hours a week. I have a Wayne County prosecutor from 9 to noon, which I can't do anything about that. That's what I have.
I understand, Your Honor.
It's frustrating. So we have to do January 13th. Mr. Riggins, she's in custody. You want to go at 10:30?
I have one matter scheduled at 9. Can we do like 11?
Sure, 11 a.m. All right.
Thank you, Your Honor.
All right. Thank you.
Also, if I'm able to provide proof to the court of her father's funeral, may I present that to the court?
Sure. Yeah.
Okay.
All
I'll
right.
contact the
Thank
family
you.
if I can get proof. Thank you, Your Honor.
All right. Thank you.
Yep. Okay. Go! Will you hand me my screen box?
Now go. Preach.
Hi, Mr. Powell. Good to see you.
Good to see you.
Unfortunately, in these circumstances, we had you go to the facility at the Ed Emmett.
The jail diversion.
Right, but
I've been there before and I completed it. I've been
So-
there back in, I want to say, 2022, and from the court number 4. And I stayed there 14 days, and they sent me to a church program, and I didn't like it. I don't believe in God. I know who created me. I don't have to believe in God because I know who created me, and I don't want to disrespect you by telling you that.
well, let's hold on, because I don't know what happened on the new cases. So give me a second. Let me have them read out what happened on the new cases so we can see how to go forward, because I don't even know where the new cases happened.
On December 25th, officers were dispatched to a trespasser call at Trinity Lutheran Church in Harris County, Texas. Upon arrival, officers observed the defendant sitting on the steps of the church, screaming obscenities and causing a disturbance. Complaining witness, a security guard employed by the church, advised officers that the defendant came to the church asking for food. And the complaining witness informed the defendant they were not giving out food that day and directed him to 2 nearby locations instead. Defendant became belligerent. Complainant stated the defendant threatened him, stating, "I see you don't have a gun, so if we fight, I'm going to kill you." As the defendant was threatening complaining witness, defendant was moving towards him in a fighting stance, causing complainant to feel fear of imminent danger. Complainant stated he told defendant 3 times to leave the location, but defendant refused.
What would you like to do, Shreya?
Well, Judge, my understanding from speaking with Mr. Powell right now is that he's okay keeping the bail as is. And so he's waiting a bail hearing. Is that right, Mr. Powell? I just want to make sure.
That's wrong.
Do you want to go back to the Ed Emmett place?
Yes, sir.
You want to try to see?
Medication. So I get my medication.
You-
Because,
What it doesn't matter. I just want to know if you want to do that.
yes, sir.
We can try to make it work.
Yes, sir.
Is that
Okay.
something you can do?
So a couple things. To do that, we would have to go through Brad Morse for the mental health, see if Brad even wants to offer that. Then I'd have to get a PR bond with the condition that he gets released there again.
Sure.
And so sort
Do
of,
you know how long that program is, Shreya?
so Judge, it actually could be 10 minutes or it could be 2 weeks. It just depends on the nature of how long they decide to keep him there. It looks like this time they kept him from the 18th until Christmas. I believe he was released on the Christmas Eve. And then this case occurred Christmas morning at about like 7 or 8 a.m.
Okay. So let's see if we can try to make it work. I need a little bit of time.
You know what? The devil created me, and I know that devil.
I don't believe that for a second.
Trespassing my creation, my creator's creation. So fuck you.
Oh, okay. Thank you, Mr. Bell.
Speak English, sir.
Yes, I do.
Morning, Mr. Caceres. Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And he is already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which
Oh,
I don't believe this was addressed on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
so are you saying that Harris County did not fax Connecticut?
No, they did fax Connecticut, but the fax numbers that they sent it to is it has to go through I can't remember if the name is inspector or adjuster, but there is a figurehead that has to flow through before it reaches the detective's desk, the actual extradition detective. And so on the third attempt, when there was no response, is our sheriff's office reached out to their sheriff's office and finally got someone on the phone. When they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021, and the warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach, after speaking with the detective, is that they weren't aware, they had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary of habitation, 1st degree, where sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with, is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
If I may, whatever the charges might be, it could be murder. It can't be murder because you can't let him out on
Right.
bond. The point is, he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now. Until he gets over there to that jurisdiction, can they find him guilty of that? So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case, because there are 2 things that he's got in place, 2 things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says, what he agreed to says, they have 14 days. It is ordered for the sheriff to hold him for no more than 14 days of the date this was signed. This is the actual order signed by the court. This is what he agreed to. Signed by him, signed by you, the judge. And so this is the agreement. The fact that somebody didn't send a fax to the correct number, it doesn't say, but if we send the fax to the wrong number, you get to hold them for 3 extra days. This says 14 days. This is what he signed up for. This is what's ordered. This is what I say should stand, and this is what I say should allow him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times there are several factors that is determinant of whether I grant an extension or not. One of the things has there ever been an extension before? Number 2, the nature of the charge. Number 3, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
Your Honor, may I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case, okay? Because the thing is that I live stream these proceedings, right? And so I don't want you to say something that you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in. And I don't know. Because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number one. Number two, the other question I have is if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go
I
do
have
that.
my family sitting in court, and they are the one, they're the one supporting me. And I know 100% they're going to support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
You need to fight those charges regardless because they're very serious charges. So Dave, what day did you say that they're going to come pick
It's
it up?
Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the.
So are they going to be here Thursday and we reset to Friday?
On Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
John, I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong
concern is not my concern. And my only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days. And I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you a PR bond. If they fail to come get you by Friday, I'm going to give you a PR bond because they have fallen on their word twice and I'm not going to do it. Now, if I were to set you a bond now, I mean, it's over 10,000, something like that to that nature. And because it's a fugitive case, there's no 10%. You're probably going to have to pony up 90 to 100% of it because you are an inherent flight risk because it's a fugitive case. So there's none of this 10% where you pay $1,000 and you're going to get out. No. In these types of cases, when we have fugitive cases, I normally set bonds, 5,000, 10,000. I've set bonds at 50,000. I've set a bond at 100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now willy-nilly. No, I would set you a bond and it's going to be a substantial bond because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
okay. But the 14 days were exactly what I signed for.
Remember, it is a courtesy. Statutorily, we can hold you here 30 days. Okay.
To address the legal part of it, if your client is stating that he is withdrawing the waiver after today, then at that point, if you're considering a refusal, then we'll start the governor's warrant process and we'll hold him to 90 days. So if that's what your client is requesting, just in terms of your argument, because you were stating 14 days, that's true. If you want to, at the end, then revoke it, then we'll request an extension to 90 days and get the governor's warrant. So.
Judge, my argument is what he signed, what the order states, and the documents filed in this case. This is what's about.
I get it. I understand that. But there's sometimes extenuating circumstances. Things happen.
Not faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days just because somebody didn't send the facts to the correct person. This
Get it.
isn't the first time.
It's a courtesy.
I get it. Okay.
We can hold you 30 days. The 14 days, I don't have to give anyone 14 days. I can hold everyone 30 days if I wanted to. 14 is a courtesy. I've told you now that I'm going to give them until Friday. If they don't come here Friday morning, I'm letting you out. And now it's on them. And I don't care. I'm going to give you a free bond on Friday if they don't come pick you up. But if I'm going to set you a bond now, the first thing that's going to happen is you have to withdraw your waiver. All the 14 days that you've accrued so far goes out the window. You lose all the time that you've accrued. If you're unable to make the bond, you've lost all that time. Then they're going to get another, another couple weeks to come get you. So give it till Friday. If they're not here, then I'll give you a PR bond. If they come here by that time, then you get up and you go fight the charges in Connecticut. And now, when you get to Connecticut, you can also, ask for a bond there. They can set you a bond there. But, the money that you would spend here just to get out, it's probably, use that to hire yourself a great lawyer there. Because the thing is that here, it's just a little wait. That in Connecticut, that's what you really got to worry about. This is peanuts. You go there, lean on your family to get you the best lawyer you can get in Connecticut so you can fight that case. That's where the concern should lie.
Thank you, Your Honor.
Remember, when you get on that phone in the jail, every phone call is recorded. Be careful what you say. Be careful who you talk to. There's a lot of jailhouse lawyers over there. They're going to tell you this, they're going to tell you that. Listen to Ricardo. He's going to direct you the best, and then we'll reset this to Friday. If they don't come Friday, I'm giving them a PR bond, and I don't give them.
Right, I'm with you, but it was remember, because the holdover issue is that it has to be set.
We'll set it to Monday.
Right.
But
otherwise he's going to be brought up in.
You'll be here Friday, right? Okay, we'll look in the system if they've come get you Friday morning. If not, if they haven't come get you, we got to set a time. What time?
Actually, they emailed confirming. Let me see if I can get a time, because they have to send it to Central Records for the pickup. So I'll see if they're able to get
We brought you here today so that you could hear what's going on, because we wanted to keep you in the loop so you know what's going on.
Thank you, Your Honor.
Okay? That's why we brought you here today, so you can hear, so you know you're in the know, because this is your case. You need to know what's happening.
Hopefully they'll respond soon. I just emailed the inspector over there. Inspector, so it is inspector. And so hopefully he'll get back to me soon. And then
We can roll it to tomorrow. That way it gives you a little bit more time to get a concrete and firm time.
I have the date, right? If it's just the time, I mean, I have no issue with rolling it just to check the time, but every day that rolls over, he still has to get brought up in the morning really early. So
what I want to do is I want to be able to commit them to a specific time on Friday. So I know I can start working on a PR bond, because I'm not giving them until 5 p.m. Friday. It's got to be in the morning, and they got to come get you. And if they don't by 10:30, then at that point I start working the PR bond for you.
Why don't we just set it for 10:30?
I mean, if I get a different time, then obviously I'll email you and I'll email the court. And so
It's got to be something reasonable, morning-ish.
I think they indicated morning, but obviously until they confirm with our Central Records.
I want to know from them specifically so that they can say, "Oh man, you didn't tell us the time." And no.
Right. I think I've only had one first specific request for an
I
afternoon.
want them to commit so that they know if they're not here by that time, he's going bye-bye.
The only concern would be is if we don't do it by the time court is done with.
That's why I'm trying to commit them to a time before court is done, so that they can't.
Perfect.
It's on them. There's no one else that they can blame.
Okay.
We can bring them back tomorrow if you want to do, maybe we're off Wednesday, right?
Yes, Judge.
Thursday, whatever you want, or we can email and then you can.
We could email and just, unless they wants to.
Well, I'm emailing the detective now because I emailed the inspector originally. I probably
They may not respond within,
Well, we could approach on it tomorrow.
Yeah,
off
of course.
docket. We don't need to bring Mr.
That's what I mean. Is
Done.
Yeah.
That's what we're doing. We're going to pick a time Friday for them to come pick you up so that they are in agreement with. So if they don't come here by that time, you're giving a PR bond.
Thank you so much.
Okay? Okay, man.
Thank you.
Okay, thank you, Judge.
All right.
I don't think we got any. Good afternoon, Mr. Rogers. This is file 242305FY. You're Patrick Lincoln Rogers II?
Yes.
I'm Judge Middleton. I'm here at the courthouse. Also present is the public defender. He's with us also, Larry Westcomb. And you got arrested last night for possession of methamphetamine and resisting and obstructing a police officer. Those are both felonies. R&O is a 2-year felony, and possession of methamphetamine is a 15-year felony, 10-year felony, excuse me, $15,000 fine, and you're on parole. So this wasn't good. So I'm going to show that you plead not guilty.
Thank you. I never had no meth on me. They found the meth somewhere sitting over somewhere.
All right, well, don't say any more about it, Mr. Rogers. I'll get a lawyer to help you with it. Show you plead not guilty, appoint an attorney, set a pre-exam for 1/14/25 at 8:30. PEX for 1/21/25 at 1. Couple of bond conditions. Pretrial supervision if you post it, no drugs and no alcohol.
I'm trying to go rehab.
No weapons, no assaultive behavior. Have you talked to your PO yet?
No, listen, so I just went to my PO, last time I seen him, I barely passed my drug test. He says, hey, look, do you want help? I said, I think I got this. Well,
who is your PO?
Jeb.
Oh, boy, he's been busy today.
Yeah, oh yeah. So, I don't know.
Well, don't say any more about it. You're not likely to bond out with a parole hold.
Well, no, because I got a violation, and I don't even know what the violation is. They told me I was absconding, and I had a violation. The marshals came to my work looking for me for no reason.
Yeah, you were out. They had an absconding warrant for you. Apparently, you missed something. They found
everything.
Okay, well, we'll get a lawyer to help you with this. Bond is $25,000 cash or surety with conditions.
So it's at 2,500?
25,000. I don't think Mr. Miller's gonna let you bond out anyway, so it may be moot. But the prelim and pre-exam day will be January 14th for the pre-exam. We should be able to get some handle on what's what by that time. 3.6 grams of meth are what they found. Have you slept yet?
Man, I'm up in this drug tank. They won't move me, Middleton. I can't do nothing up here. There's a girl yelling, screaming her head off. They won't move me.
Yeah, I hear them. They're gonna move you now that I set the bail.
About now, like you said. So I'm just trying to get back to where I can rest and get back where I'm supposed to be, man.
Fair enough. All right, Mr. Rogers. I'll see you on January 14th at 8:30. All right, thank you. Hello, Ms. Davis.
Hello, Judge.
You got some droopy drawers here. We are addressing now the matter of People versus Amber Lynn Stevens. That's you?
Yeah.
Ms. Stevens is here. She's charged with domestic violence, third offense, and resisting and obstructing a police officer. Those are both felonies. The resisting and obstructing charge is a felony punishable by up to 2 years in prison. The domestic violence third offense is a felony punishable by up to 5 years imprisonment. The matter was set for a pre-exam conference this morning, and Mr. Robert was here from the prosecutor's office, and Mr. George was here. Ms. Stevens was not. She called and said she couldn't get here or wasn't going to be here. And Mr. George said she had not contacted him and made any effort to discuss this case prior to the hearing. So I advised staff to advise her that she needed to be here. And so she did come. It's now 1 o'clock. This incident was December 18th. The defendant posted bond, I think the very next day, a $10,000 bond, and then didn't show up. So rather than issue a bench warrant for your arrest, I thought I would see whether you did show up. The prosecutor has made a plea offer, according to Mr. Robert, that they would dismiss the domestic violence third offense charge and the assault and resist a police officer felony for a plea to attempting to resist or obstruct a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Because you never contacted your lawyer, he's never had an opportunity to discuss that with you. What happened this morning?
Well, this morning I had gotten the PEC and the prelim mixed up. And I also had a interview this morning at another job at 10 a.m. And I guess I had just gotten my times mixed up between everything going on and arranging the ride here, really.
Well, where are you staying?
I'm staying on South Street and Flowerfield. It's in my grandparents' rental property, and the lady that stays there, she's not there right now. So they're letting me just kind of like stay there temporarily as we have no contact. Me and my grandma don't have any contact.
Yes.
Yeah.
All right, we have a couple options. One is to put you in jail and let you sit there and make sure that you show up for your next hearing. You won't need to have a job application if you're going to be sitting in jail. So this is a priority over other things. And I guess I have to cut you a little bit of slack because there were some holidays in there. But this happened, you got an attorney appointed for you on December 19th. Today's December 30th, and you never called your lawyer to make an appointment to discuss it with them. What's up with that?
I was meaning to. I can get into contact with him immediately after this.
Same thing. If I put you in jail, he'll be able to come visit you in jail. I'm not very happy about this. You didn't bother to call your lawyer. This is about the 4th time you've been charged with assaulting your grandmother. Alcohol was involved, according to the affidavit of probable cause. You don't make the slightest effort to call your lawyer. You don't show up when you're supposed to. You show up 5 hours late at an inconvenience to everybody else. And it's not a good situation. There's an offer of a misdemeanor, but I don't think you're prepared to discuss that with your lawyer. He's not here. Mr. George, would you ask me to adjourn this?
Yes, Your Honor. I just signed some substitutions for matters that are set for next Tuesday. So I just asked that this be set alongside with those because I'll be there anyways.
You are hereby ordered to call your lawyer. Now, there are going to be 2 vacation days. All right, as you indicated, there's a no contact provision. So you're not to have contact with your grandmother. You're not to use any drugs or alcohol. You're not to get in any other trouble. And it's an additional order that you call your lawyer on Thursday, January 2nd, to discuss this matter with him. Somebody put up money for a $10,000 bond, and you don't want to forfeit that. It's file number 242306FY, People versus Scott Raymond Griffiths. Prosecuting attorney-elect Deborah Davis is here. I want to call her that for one last day. And Mr. Larry Wescombe is here for the Public Defender's Office. You've been charged with domestic violence aggravated as a second offense, making that a felony punishable by up to 5 years imprisonment. Count 2 is domestic violence, second offense, which is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. They also charge as a fourth habitual offender, making that 5-year felony offense, I believe, life offense, maximum. It's alleged that this took place on December 29th out in Leonidas Township. Ms. Davis emailed me and she wanted to be heard regarding your bond. Let me ask you a couple of questions. Are you still living in Vicksburg?
Yes.
Who do you live with?
My oldest daughter is living in Spring right now. My youngest daughter, Brooklyn, that I have a kid with Miss Merkel. Her oldest daughter that just had a baby, and her baby daddy, and Karen.
Oh, Karen lives there also? All right.
Yeah.
Are you employed?
Yes.
Where's that?
Lakeshore Construction.
Who's that?
It's a construction company out of Lawton.
Okay. I was looking at your stuff, getting prepared for this, and I've known you for a long time. You have 84 separate entries in our system since you turned about 17. Ms. Davis wanted to give specific input on this. Ms. Davis, what would you like me to know?
Your Honor, in reviewing this case, the concern is that this is a continual issue with domestic violence, and this individual, he most recently had a domestic charge, 2 domestic charges in Indiana. He pled to one for a dismissal in the other.
Where was that?
That LaPorte County. There was also an residential entry, intimidation, and battery in Elkhart County that I'm waiting to hear back from Elkhart to see if the assault and battery that he pled to was actually domestic, but I haven't been able to get the details on that yet. He also, with the same victim in 2019, was charged with assault with a dangerous weapon. He ended up pleading down to disturbing the peace. He's had multiple instances of driving issues, reckless driving. Dangerous driving was a part of the issue here. This is alleged to have happened in his motor vehicle while they were traveling down the roadway on Michigan Avenue up in Leonidas Township. He's had prior meth charges, resisting and obstructing police officers. He's got both the Indiana record and the Michigan record. With what has occurred here, the victim reported that she is very scared. She was afraid that he was going to come find her. She was hesitant to even go to the hospital because of her fear of him coming to find her. So I would ask that the bond be set as a cash bond with provisions that he have no contact with the victim or her place of residence, that he be placed on a GPS monitoring so that we can keep track of where he is to ensure the safety of the victim, and that there be no drugs or alcohol. It was alleged that there was alcohol as an issue here in this one, and he has a prior drug history. So with that, I would ask that it not be a 10% bond either. I'd ask it to be set as a cash bond and an amount that the court deems appropriate. Thank you.
I can take a drug test. That had nothing to do with
All right, well, just a minute. The bond information report indicates that she went to the hospital, to the emergency. Do you have the medical information on this yet?
I don't have the medical records. I just have from her that she was treated at the hospital, and was told to follow up with her primary care physician.
It was all about custody of our daughter. Okay,
Hey, sir, stop.
Well, what she says in the plain old vernacular is that you beat the shit out of her and she got out of the car.
If that was the case, she'd be all beat up.
Stop. I don't want you to say anything that might implicate you in any of this. So I'm not unwilling to hear what you have to say, but at this point, it's probably best you don't say anything. There's a lot of baggage on here. There's a couple of DVs that were charged and either dismissed or reduced to something else. There is a domestic violence from 2019, which is the precursor for this case.
Yeah, I have evidence showing.
Now are you on probation or parole?
No.
In Indiana or here?
No.
Do you have any charges pending in Indiana?
No. I'm not a violent man.
All right, well, don't say any more. Your record speaks differently. You got R&Os, disturbing the peace, several prior DVs, not to mention all the other stuff. But Mr. Westcomb, you have any input on this?
Yes, Your Honor. While these are serious accusations, Mr. Griffiths has acknowledged to me that he will abide by any terms of bond that the court sets, including alcohol and drug testing, and he has a place to go, so there will be no contact with the alleged victim in this instance. The threat to the public, as far as that can reasonably alleviated with a GPS tether, as the prosecutor has suggested, and he has indicated to me that that is something that he would submit to. He's gainfully employed. He has been for some time. With all these factors taken into account, we would ask the court to consider, if it sets a high cash bond amount, to consider 10% so that he can assist in his defense. Thank you.
Mr. Griffiths, tell me more about this Lakeshore Construction.
He's respectful.
Well, do you have a project that you're working on right now?
Yes, I was supposed to be finishing a job over by Saginaw on a roof. We always have projects. We're busy all the time. I mean, I'm running.
All right. Do you have a valid driver's license?
Yes.
You do?
Yeah.
Oh, good. All right. Well, there are public safety concerns. Let me look at this praxis report that I didn't get. The defendant has at least one prior conviction as an adult. The defendant has 2 or more prior violent convictions. The defendant has a history of drug abuse and does not include alcohol. They recommend pretrial supervision.
Whatever I gotta do, I just gotta be out working. It's not gonna be
now. Everybody wants to get out. I certainly would agree with that. There's a public safety component to this. Your girlfriend contends that you beat her. She got dumped out of the car or jumped out of the car, hid to avoid you finding her. An ambulance came. They took her to the hospital. The police didn't mess around. They went right to your house and arrested you in Vicksburg and took you to jail. So there is a public safety issue of it. All right, well, let's talk about the test as directed 2 times. No drugs, no alcohol. No drugs, no alcohol. No contact with Karen Merkel. No weapons, no assaultive behavior, pretrial supervision, including GPS tether. He has $10,000 cash or surety. This is a second offense, aggravated domestic assault, as a 4th habitual offender. I take this quite seriously. So you got the conditions. If you do post the bond, you'll have to contact the Community Corrections Department. I'm going to appoint an attorney.
How much is this?
$10,000 cash or surety.
So if I go through bonds, maybe 1,000?
Yes. PEC for 12/14/24 at 8:30.
114, run, 25.
114, thank you. 25 to 114/25. Let me get that right. And a prelim if needed for 121/25 at 1 o'clock. Mr. Griffiths, I don't even know what to say about this. At this time, you're presumed to be not guilty. You have a presumption of innocence that follows you throughout this. But I am concerned about this and about you. So I'm not going to do a 10% bond. I'm not going to set it at an outrageous amount, but I have a serious concern about her safety. All right, you're good to go.
If you give me the opportunity, I'll show you.
This is file number 242307 FY, People versus Caden D. Hasselkuss. Mr. Hasselkuss was here earlier this month on a disturbing the peace. These charges are significantly more serious. It's alleged that on or about December 20th in the city of Three Rivers, did carry or possess butane, an explosive or combustible substance with the intent to damage or destroy property without permission of the property owner, and did damage property belonging to Goodwill Industries. It's a felony punishable by up to 20 years imprisonment and a fine of up to $15,000.
Your Honor, that was on December 29th.
Oh, December 29th. Yes, I'm sorry. Count 2, did being a person 18 years or older possess methamphetamine within 1,000 feet of a school, which is a 20-year felony. I have not seen that charged this year, I don't think. Count 3, arson, preparation to burn. Did arrange, place, devise, or distribute an inflammable, combustible, or explosive material, liquid, substance, or device at or near Goodwill Industries with the intent to commit arson of property having a value of $20,000 or more. Officers were dispatched to a large fire behind the Goodwill store. And there's video of someone they believe to be you. Wow, setting this fire. Damaging a truck. You had some methamphetamine in your possession when they arrested you. Mr. Hasselkuss, are you on bond in any other jurisdiction?
Yeah.
Elkhart?
Did you say St. Joe?
All right. Are you still homeless?
Yeah.
And you said you're on bond from where?
St. Joe.
I don't think he is. The only case that I'm showing is the one that
He owes money on.
Right.
Well, then the praxis is not right. All right. Miss Deborah Davis, the soon-to-be prosecutor, is here. She wanted to give input on this. Miss Davis?
Right, I've been in contact with Three Rivers Police Department, who have been investigating this issue, and they are very concerned about the safety of the community with this individual. Most recently, at the beginning of December, he was charged with using a baseball bat to hit the backside of a car of an individual. That was the case that he came in and ended up pleading to disturbing the peace. Didn't really have a great explanation for why he did that. I thought they were laughing at him or talking about him or something.
Yes.
And, I had some concerns about him at that point. So when this came in and we start looking at the details, this could have been extremely serious as far as but for the security company from one of the neighboring businesses having a good monitoring system, that an individual called in from Detroit directly to the fire department, and the fire department was able to get dispatched out there much more quickly than usual and get it under control. But the butane that he is alleged to have used and admitted to using, and burning these pallets that were up next to the building, creates a very dangerous situation for the community and for all the firefighters and personnel that need to be out there to take care of that. He didn't really have any qualms about telling the officers that he had done it, didn't really have a reason, which is concerning. And then the methamphetamine being at the soup kitchen where he was found within, about 500 feet of Ruth Hoppen Elementary. And he didn't mention anything about having that. It was then found on his person when he was threatening to swallow it in the police car. I think he's got some pretty significant issues going on right now. And the fact that he is homeless, doesn't have anywhere to go, and this is the second crime that he's committed in this month, I think for public safety reasons and to ensure that he appears and is clean and sober for the proceedings, I would ask that the court set a high bond, no 10% option, and that he be outfitted with a GPS monitor. Thank you.
Mr. Westcomb, anything you wish to add?
Yes, Your Honor.
Given all the things that the prosecutor has mentioned about these charges, they are severe charges, and I would just like the court to consider the fact that the defendant here is homeless and has access to very limited amounts of resources, and to consider his lack of resources when setting bond. Thank you.
Thank you. Mr. Hasselkuss, I dealt with you earlier this month, that incident where you broke the taillight out of that car with a bat because you thought people were laughing at you. Maybe they were, I don't know. But anyway, it was upsetting to you. And I could tell at that point that there were some mental health issues, but I didn't really delve into it. I just let you out of jail and gave you a fine and time to pay it. Maybe it needed more attention than that. This is scary and frightening and makes the hair on the back of my neck stand up. According to the video, you stacked those skids or pallets up there, put stuff on it, lit it with a butane torch, and caught a semi on fire that burned up, doing substantial damage. And only because of somebody else's security, that whole strip mall would have burned up all the way down to probably Bigby Coffee. That would have been the biggest fire in Three Rivers in the last 100 years. We're going to need to get some probably mental health involvement here. But this is very frightening. There's no reason for it. Great risk of public harm. And I'm going to set bond at $100,000 cash or surety. The public safety implications of this case are very large. As a practical matter, as Mr. Westcomb said, you don't have very many resources. But I asked you this when I saw you earlier this month. Where are your people? Where's your family?
Is this me?
Where do your parents live? All right. Much as mental illness and a combination of both, but there's a great public safety risk. So I'm going to set the bond conditions at no drugs and no alcohol, no weapons, no assaulty behavior, and pretrial supervision, including GPS tether, if you do bond out, which is not likely. But that's by for your safety and the safety of the public right now, the best place for you to be is where you are. Perhaps there could be some other sort of mental health placement. That to be determined. Anyway, I'm going to appoint an attorney. I'm going to set pre-exam conference for January 14th, 2025 at 8:30 a.m. That's your next court date. And if we do need a preliminary examination, you essentially admitted everything to the officers. It's probably under the category of something that will seem like a good idea at the time, but as we're talking right now, you probably don't even really know why you did this. But we'll try to get to the bottom of it. All right, your next court date is January 14th. We'll appoint an attorney and they'll come out and see you at the jail. Hopefully maybe after a day or two of for sobriety, you'll be in a little better communication. All right, good luck, sir.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a capital joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're gonna start bringing people in person. He's gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.